In today's topic, we are addressing legal aid, inequality of arms, and the procedural economy of family proceedings. When access to justice becomes conditional upon financial endurance. This is Silent Screams, Loud Strength, Unmasking Justice. I'm your host, Samantha. One of the greatest myths inside modern justice systems is this: everyone enters the courtroom equally. No. The architecture of the courtroom suggests balance. Two parties, one judge, one process, one law. But beneath that appearance is one of the most profound structural inequalities inside family proceedings. Yes, you heard me right. Equality of arms. Because access to justice is no longer determined simply by the law, the facts, or safeguarding concerns. No. Increasingly, it's determined by money, procedural stamina, access to legal infrastructures, emotional endurance, and the ability to survive prolonged litigation psychologically and financially. This is not merely a legal issue. This is a safeguarding issue. A participant party possesses professional legal teams, financial insulation, procedural fluency, and unlimited litigation capacity, while the opposing party is traumatized, self-representing, financially exhausted, psychologically overwhelmed, and attempting to survive coercive control simultaneously. This is not equality before the law. This is procedural asymmetry institutionalized through structure itself. So today we are discussing legal aid, litigants in person, procedural imbalance, and litigation exhaustion, disclosure, warfare, participation impairment, and the procedural economy of family proceedings. Yes, domestic abuse has become commercialized because increasingly justice is not being determined by truth alone. It is being shaped by who can survive the proceedings the longest. I'm your host, Samantha. Please subscribe to my channel and share the content with your friends so that the channel can grow and can be recommended to other people too. While our podcast Silent Screams Loud Strength streams on all platforms. So let's jump back into it. What equality of arms actually means. Equality of arms is a principle of equality of arms sits at the center of procedural fairness within family proceedings. Under the Article 6 of the Human Rights Act, a fair hearing requires that parties have a responsible opportunity to present their case without substantial disadvantage relative to the opposing side. Now, while on paper this sounds straightforward, but in practice, family proceedings increasingly reveal something much more uncomfortable, and they are family courts, because equality is not created merely by allowing two parties into the same room or into the same courtroom. True participation requires that the functional access, procedural understanding, and emotional capacity, legal literacy, financial endurance, and the ability to withstand adversarial pressure over time. This is where the concept becomes operationally important. A traumatized litigant in person facing a represented party or parties, multiple barristers, extensive bundles, procedural complexity, and ongoing litigation pressures may technically be participation, but participation in this form is not the same as participation in substance. And this distinction matters enormously because coercive control frequently evolves procedurally. After separation, it can mutate into the courtroom itself. The courtroom may become the continuation of domination through process and procedure. So the collapse of legal aid and its consequences in the family courts. The reduction of legal aid fundamentally altered the landscape of family justice. The consequences were not merely administrative, they were structural, because once legal representation became increasingly inaccessible, the burden shifted directly onto the traumatized individual. So how can one survive the process? Survivors of abuse, parents in crisis, and litigants already have this psychological destabilized state of being. So now let's think about what that actually means operationally in a family proceeding. A survivor may be expected to prepare the bundles, understand procedure, interpret the court orders, challenge disclosures, draft statements, navigate hearings, understand safeguarding law, and advocate under pressure against their abuser while simultaneously parenting, surviving, financially processing trauma, and attempting emotional recovery. These are profound circumstances. This is not merely difficult. For many people, this can be an impossible neurological overwhelm that they cannot fully function or understand. And this is where the procedural inequality deepens, because represented parties process, legal teams procedural fluency, they have them to draft, the capacity is managed strategically, they have strategic advice and institutional familiarity. Meanwhile, a self-representing survivor is often attempting to learn the system while surviving it with not enough information. That is not equality of arms. That is disparity. This is structural imbalance disguised as procedural fairness. So the procedural economy of litigation. We need to discuss this for something extraordinarily important, actually. Litigation itself has economic architecture. Every hearing costs money. Every adjournment costs money. Every application costs money. Every delay costs money. But the cost is not merely financial. It is cognitive, emotional, psychological, relational, and psychological, difficult for the body to process the mind. This is why litigation exhaustion becomes so operationally powerful in coercive control cases, because proceedings may evolve into procedural attrition systems, repeated hearings, late evidence, sudden procedural shifts, extensive disclosures, demands, ongoing correspondence, threats, escalation, financial instability. It all causes survivors lack of participation, that when participation capacity begins to collapse, not because the facts disappeared, but because the nervous system cannot remain in a perpetual survival mode indefinitely. So this is not something that a survivor can control. This is one of the least recognized safeguarding realities inside family proceedings, actually. This process itself becomes traumatizing. Going to court is not easy, not for anybody. So the litigant in person is vulnerable, and yet they are supposed to perform as though they understand the law and speak and be heard and present their case. Now let us discuss litigants in person. The real system frequently treats self-representation as an administrative category, but in many domestic abuse proceedings, self-representation is actually a safeguarding vulnerability, because litigants in persons are often procedurally disadvantaged, psychologically overwhelmed, financially exhausted, and institutionally unfamiliar with the adversarial system, yet courts frequently continue expecting them to perform procedurally, fluency, maintain the emotional regulation, comply with complex directions, and advocate under pressure. This creates enormous danger where trauma already affects concentration, memory, organization, sequencing, and communication. So how can you communicate while overwhelmed? So presentation, represented parties may strategically utilize the procedural complexity, aggressive correspondence, extensive filing, and litigation pressure to destabilize participation further. So this is where coercive control becomes procedural mediated. The abuse evolves through process, delay, pressure, and overwhelm of the institutional structure. Disclosures, welfare, and financial distortion. Now we need to discuss the disclosures, Form E, because one of the deepest structural inequalities inside family proceedings concerns access to financial visibility, where one party opposes corporate infrastructure, financial advisors, complex business structures, or extensive procedural resources, financial realities itself may become difficult to penetrate. This creates what I describe as financial distortion. And this is where the alter ego problem becomes operationally important within family dynamics and family proceedings, because the court may encounter situations where lifestyle indicators, business structures, assets, accessibility, corporate positions, and disclosure narratives do not align coherently. And yet, self-representing survivors frequently lack forensic accounting, access to disclosures, expert financial investigative capacity, or procedural resources to challenge complexities efficiently or effectively. Meanwhile, the litigation continues, costs escalate, participation distorts, deteriorates. This is not merely financial imbalance. This is evidential asymmetry. And evidential asymmetry directly affects safeguarding fairness. Why? Because psychologically, consequences of procedural imbalance make it really difficult for someone who is deeply traumatized and yet functionally trying to advocate for themselves. Now let's discuss the psychological consequences, because prolonged procedural imbalance changes people neurologically. Constant participation, constant threats, constant instability, constant uncertainty. The nervous system adapts into a survival mode. This may produce hypervigilance within the survivor, emotional flooding, exhaustion, cognitive fragmentation, disassociation, panic attacks, or a shutdown response, because the nervous system is overwhelmed. And yet the legal system frequently interprets these responses through credibility frameworks, procedural expectation, or emotional performance standards. This is deeply dangerous, because trauma-related participation impairment may then become interpreted as irrationality, instability, unreliable, or emotionally volatile. This is why many survivors describe family proceedings not merely as stressful, but as psychological disintegration, if ever they have the language for it. The process itself may become a continuation of coercive control, because the gap between self-representation and a represented party is big. So self-chain structural access to justice. This is where self-chain comes in. Self-chain argues that access to justice cannot remain dependent upon wealth, procedural stamina, or emotional endurance capacity. Justice systems require structural participation safeguards. This includes trauma-informed procedure, participation, continuity, disclosure, transparency, contextual safeguarding, analysis, evidential continuity, and across systems, accountability across systems, equality of arms before the law is meaningless. Because without structure, without participation, one party is structurally equipped for litigation while the other is structurally collapsing beneath it. This is not merely procedural inefficiency. This is institutional inequality, and unless systems evolve structurally, family proceedings risk continuing to reproduce power imbalance, intensify coercive dynamics, and erode public confidence in the justice system itself. So, the issue is not whether courts matter, they do. The issue is whether access to justice remains genuinely accessible once trauma, coercive control, financial imbalance, and procedural exhaustion enter the courtroom. Because justice is not measured merely by whether hearings occur or whether procedures are followed. Justice is measured by whether people can survive. Participation itself cannot be psychologically and economically dismantled in the process. And until equality of arms is treated as a safeguarding issue, a participation issue, and a structural justice issue, many survivors will continue experiencing litigation not as protection but as prolonged institutional attrition. This is Samantha. Silence screams loud strength, unmasking justice. Do follow us on this channel. This was Masterclass 9, Legal Aid, Inequality of Arms. We are on YouTube, so follow us, subscribe, share with your friends. Until next time, this was Silence Screams Loud Strength, Unmasking Justice.